Subcommittee will come to order. Thank you, everybody, for attending this hearing on the Office of Compliance. This is maybe our fourth or fifth hearing in the last week or so as we work on our FY 2019 appropriations legislation. And so we appreciate Ms. Grundmann coming to attend the hearing today. I don't believe we had a hearing with you last year, my first year chairing the committee, so we're thankful that you're here this year. And I know from time to time you are brought in for hearings and sometimes you aren't. So we're glad you're here, and we appreciate your work. Ms. Grundmann is the Executive Director of the Congressional Office of Compliance, established by the Congressional Accountability Act of 1995. The Office of Compliance is tasked with dispute resolution, safety and health compliance, labor management relations, and educational offerings across the legislative branch. Over the past year, the office has received much attention as the House has debated how best to ensure employing authorities, including members of Congress, are held accountable for employee rights that are violated under their watch, as well as making sure employees know and understand their rights and have access to a dispute resolution process that is fair, easy to navigate, and is not layered in burdensome bureaucracy. The House has taken action in 3 ways to address workplace harassment. We passed House Resolution 630, which makes in-person workplace rights training required for all members and employees. We passed House Resolution 724, which established an Office of Employee Advocacy with the mission of providing legal assistance to House employees regarding Congressional Accountability Act procedures. And finally, the House passed Comprehensive Congressional Accountability Act reform that continues to be debated in the Senate. The implementation of the 2 past House resolutions has been the responsibility of the House Chief Administrative Officer because they are House-specific and not legislative branch-wide. However, it has required close coordination with the Office of Compliance and will certainly have an impact on their operations moving forward. With all the attention the Office of Compliance has received over the last year, their profile has certainly been raised. They have seen a triple-digit % increase in requests for training, both in person and online, in addition to increased service requests across the board. Also worth mentioning is, as a result of the fiscal year 2018 omnibus, the Office of Compliance's jurisdiction has been expanded to include claims submitted by employees of the Library of Congress. This expanded jurisdiction, I believe, is a good thing, but will likely result in an increase to the Office of Compliance annual caseload. With all that being said, the revised budget request for fiscal year 2019 operations is $5,410,210.89, which represents a 9% increase from enacted levels. Thank you for joining us today, and now I'm going to yield to my good friend from Ohio, Mr. Tim Ryan.
Thank you, Mr. Chairman. I appreciate it, and I appreciate this hearing. In my opinion, this hearing is going to be one of the most important we will have this year in this committee, and the discussion we will have today couldn't be more timely. Across the country, industries and organizations are reckoning with the dark reality of workplace harassment, especially sexual harassment. It has become abundantly clear that Congress is no exception to that. And the elected officials here in Washington are being called to lead, and we must answer that call. How can we expect others to follow our example if we're not willing to fully acknowledge the problem and take concrete steps to address it? It was my pleasure with the chairman to support the resolution that mandates required training for all members, House employees, and interns, and I look forward to learning more today about how this training will be implemented. The Office of Compliance plays an essential role for the employees of this institution in advancing workplace rights, safety, health, and accessibility. Today, this hearing will shine a light on the upcoming efforts by the OOC to make this historic institution a safer place to work. And every man or woman who wants to work for the United States Congress should feel comfortable and safe coming to work. No person should show up to work in the halls of Congress, their government, and be forced to worry that it will be a toxic work environment where they will be harassed or assaulted. I will close by thanking the staff and the OOC for carrying out this mission and for testifying here today, and I look forward to working with you in the upcoming year to make all of this and our goals here a reality. So thank you for being here with us. Mr. Chairman, I yield back.
Thank you, Mr. Ryan. Ms. Grundmann, your complete statement will be made part of the record. Feel free to summarize your remarks at this time, and I now recognize you for your opening remarks.
Thank you very much, and good afternoon, Chairman Yoder, Ranking Member Ryan, and distinguished members of the Legislative Branch Appropriations Subcommittee. On behalf of the Office of Compliance, it is our honor and privilege to have this opportunity to discuss our fiscal 19 budget with you. We thank the subcommittee and the staff Jenny, Tim, and Adam over there, and everybody else. We thank you for your support in reinforcing our statutory mission, which, as you both note, is both broad and diverse. That is to ensure the health and safety and public accessibility of the legislative community, to provide a dispute resolution process for covered employees in our jurisdiction, and to inform and educate this community and the public about the rights and protections under the CAA. The members of this committee have led by example. You have led by, as you note, passing landmark legislation mandating in-person workplace rights training and protection for every member of Congress, both paid and unpaid staff, with new hires receiving the same training within 90 days. You demonstrate that you hold yourselves to a higher standard as the elected leaders of our nation. What a year it has been at the OOC. From a little-known office this time last year to the focal point mandating accountability through reform. During the past 5 months, our tiny staff has been tested, weighed, and found not to be wanting. Since October, our staff personally trained over 15,000 employees in the House and Senate alone, and not all at once, but in ones and twos and tens. Training to prevent sexual harassment, discrimination, retaliation is now mandatory in the halls of Congress, and our posters notifying employees of their rights are now prominently displayed in every office in the House of Representatives. But training is the floor, and training is only a means to an end, and that end being a change in our culture, whereby we have strong principles of collegial respect in the workplace and where problems are prevented before they occur. In order to meet that goal and to meet our statutory goal to educate, we require your continued support for funding and for staffing the positions to take on this challenge. We no longer live in a world where it suffices to train on the legal meaning of the letter of the law. In order for true change to occur, and for us to honor the spirit of the law, we must educate on the behaviors, biases, and practices that could lead to harassment, discrimination, and retaliation, that could create a hostile work environment. So we must continually update the tools of our training and methods of delivery to keep education fresh, relevant, and real. This is our constant challenge, to update what we have developed and to create new tools to engage our legislative colleagues. And to meet this occasion, we currently have everybody training on staff, our ADR staff, to our safety inspectors, to our attorneys in our general counsel's office, and it is still not enough. Because our daily work continues. Biennial inspections of almost 18 million square feet of the Capitol complex, responding to concerns of hazards and public accessibility, counseling of legislative employees, mediations and hearings, which, as the chairman notes, will now markedly increase as a result of the library coming under our jurisdiction. We welcome the library to our dispute resolution process, knowing full well that our caseload will only increase, thus increasing cost and the need for more personnel. Mr. Chairman, Ranking Member Ryan, we are grateful for the funding we received in 2018. And even given our limited resources, we still think we do an amazing job. Inspections are now complete in the House, and we continue to enjoy a 100% affirmance rate by our reviewing court for our board decisions. All our successes are documented in our annual report, which was released on Friday. Copies are available to you. However, as we continue to reach out, we realize just how much more we need to do, such as to bring our case processing system into the 21st century by bringing e-filing to OOC, as mandated by the CAA Reform Act that passed the House in February. Now, whether or not we see full CAA reform at the end of Congress is yet to be seen. Pending funding, we intend to and hope to move forward with this measure. As always, our budget's mission consists almost entirely of funding for people, not things. The 20 women and men who report faithfully each day to work are a testament to our commitment to excellence and efficiency. Having weathered our most challenging chapter in our history, we now move forward with you, knowing that your support has been crucial to our continued success. thank you for the privilege of your attention. I look forward to answering your questions.
Thank you for your testimony, Ms. Grundmann, and again, welcome to the committee, and we appreciate all of your hard work. You know, at the beginning of my comments, I mentioned, and as did Mr. Ryan, a number of the acts that Congress has taken already in this 115th Congress to take steps to curb workplace harassment, things like mandatory training, employee advocacy office, proposed process changes to the OOC. Those are things that are needed, but I guess a couple questions for you. What are our biggest impediments within your office to being able to resolve and help with complaints? Is it any structural issues? Is it mostly resources? I know you've asked for a 9% increase. What will that allow you to do? Sort of discuss how we can best help you do your job, first and foremost. And then second of all, what are other solutions that Congress should be looking at in general that maybe we haven't pursued legislatively yet that we should be?
Sure. There are a number of things. Our main need is people. The statutory mission is broad. It's purposeful. It has all sorts of different kinds of aspects to it. But our current issue is we have one person performing 4 to 5 functions, and that's part of our FTE request. We've trained these hundreds and hundreds of people over the last 4 or 5 months with 2 people who currently perform other jobs. We don't have a single person dedicated solely to training. So in terms of our request for FTE, we are looking for 5 to be allocated in the following fashion. We would like 2 dedicated to education, 1 specifically dedicated to the website. We don't have anybody solely dedicated to the website. And the website is an important tool because this is how we reach the staffers in your home districts, in the state and district offices. There are 15,000 people in the field. That's half of the legislative community. The second FTE we want to dedicate to have that sole person to not only develop and to update the training, but to deliver in-person training on demand. 2 other FTE, and this will give you a sense of how our staffing works. We're asking for 2 attorneys, 1 specifically dedicated to the board's functions. Currently, as we are staffed, we have 1 individual who not only researches and writes the decisions for the board, advises the board, writes procedural regulations, assists the general counsel in reviewing his briefs and preparing him for hearings, and serves as legislative counsel. So this 1 individual is performing 4 to 5 different functions. In addition, our general counsel needs more support. We're seeing an increased amount of litigation in the federal circuit, and those types of cases are more complex. They do take longer to prepare. Finally, the last FTE we would ask that be dedicated to something as simple as administrative support. As we are currently staffed, we have 1 administrative assistant supporting the entire office and the 5 board members who are scattered throughout the country. So FTE are very important for us. In terms of changes that we saw through the Reform Act, as we testified before the Committee on House Administration, a number of those changes were incorporated and adopted in the Reform Act that passed the House. We are very encouraged by that. We'll have to see what happens in the Senate. Our staff has been put in an enviable position of chasing proposals because we're never sure which proposal will come through, which is why you've seen our budget change over the many iterations over the last few months. Clearly, if the legislation passes at the end of this year through the Senate, then there are other things we will have to come back for, particularly funding and staffing for the investigatory authority and funding for the climate survey, which is under the CAA Reform Act.
Mr. Ryan?
Thank you, Mr. Chairman. One of the questions I had, we were all received notice recently about attending sessions, whether in Washington, D.C. or throughout the country, and my office and I received ours last year, which was very well received in our office. However, to do a similar type of training this year, the office-only sessions would cost offices $4,275. Can you explain to us the cost breakdown for that?
That's not us. That is It was decided by CHA that the primary training function would be undertaken by a private contractor, and that does not, we do not qualify for certification purposes. Let me note that the training that will be provided specifically only covers the House, doesn't cover the Senate or the other legislative offices. In addition, the training that will be provided to your office for certification purposes only covers one aspect of the law. The CAA covers 19 different laws that will generally, I'm assuming, not be included. Furthermore, even though we don't qualify for certification purposes under 630, and I know your office attended our session, members still continually reach out to us to conduct personal training. And the training that we conduct is specialized. It'll be bystander intervention training, unconscious bias is coming online in May. Those are the types of training that lend themselves easily to in-person training in small groups, in the ones, in the twos, and the tens, not a room full of 500 people. So as members still continue to reach out to us, some members have actually asked us to travel to their district and home offices to train their staff. We don't like to say no, but the travel is not reimbursable by the member's office because there could be a conflict of interest. So we pay for that ourselves, so that you see some additional funding allocated in our 19 requests towards travel, right? We're very proud of what we do. We have not seen what the contractor is going to do. Certainly, we will be there to assist this contractor should he so request. But, you know, feel free to continue to reach out to us. I mean, we're doing some very cutting-edge things. We have new technology in our training, which is interactive. Let me also emphasize the importance of having the small setting so students, people who are attendees can engage the educator in questions and how to handle a troublesome scenario, and we develop those. We also customize our training for individual offices. So if you have a particular interest or particular questions you want to ask in your office, we can build them into our presentation.
Of the budget request this year, how much of that is for travel?
I can't recall, but it was an additional, it was only a few $1,000s. Yeah.
Okay. Okay, yield back.
Ms. McCollum.
Thank you, Mr. Chair. You mentioned in your testimony a poster that every office would have received dealing with sexual harassment.
Right.
I've never seen the poster. I just conferred with my staff, my LD, and everybody else. No one else has seen this poster. Can you tell me when this poster was delivered? And are other members familiar with this poster? Maybe my office didn't get it slipped underneath the door. Here's a copy of it.
We can get one to you.
Well, no, I asked you when they were delivered. Do you know when they were sent out? So I can figure out what happened in my office that
We've had a number of people actually come to us. We've also gone around and delivered them. If we missed you, we can get one to you.
oh, we'll make that happen. Can you explain the website person, and if you have that person writing programming, that person just maintaining the website, what are going to be the duties and roles and function of the person doing the website?
We currently have a contractor handling the website, but it's not a full-time position. The individual will be updating each module annually, along with creating new content. You can't keep the same thing on the website all the time. It gets boring.
Yeah.
So we do have revolving content. There are modules that are being created right now that will be, we had the bystander, excuse me, let me go back. We have a new anti-sexual harassment, discrimination, and retaliation module that was loaded in January.
So right now you have a contractor who's doing that part-time, and that is going to be a full-time plus a part-time contractor? Is that part-time contractor going to be full-time?
If there's a technical expertise, I think we would reach out to the contractor, but I think in terms of the content alone, that's the time-consuming part of our project.
So you're going to, and I just want to understand, I'm not disputing what you're putting forward or your vision.
Mm-hmm.
So you'd keep the part-time contractor for when you needed something very technical done. And so the person who would be doing the web would just be doing web content. It would be more of the sense of a communications person, a
Yes.
writer.
Yes.
Okay.
Yes.
And then, so I hear what you're saying about your attorneys being overstretched, putting another attorney on. what would be, you must, what's going to be the cost of putting another attorney on in the office?
Depends on how we set the pay. It's the pay and benefits. I believe our calculation was with the benefits and the pay about $200,000 per person.
$200,000 times 2.
Times 2.
And currently you have one.
We have one attorney dedicated solely to the board, but he is doing other functions.
Right. Well, I can certainly appreciate it because my staff is overstretched and we haven't seen, except for security, any raises or anything going in to our staff and that. So under the Library of Congress coming in, so you're just absorbing that cost? You're not doing a charge back to the Library of Congress?
We can't.
You can't?
We can't. Let me explain what's going on.
No, that's fine.
Yeah.
That's
Right.
the answer in and of
Yeah,
itself.
right.
So the Library of Congress will have that as less of an expense in their budget because they won't be doing that in-house anymore at all?
Let's have this conversation. This is important to understand. Just to be clear, the library's internal process does not go away. It's still available to employees. Nor does the library's collective bargaining agreements that they have with their unions. There's an arbitration proceeding that still stays in place. What the omnibus does is it brings library employees into our process for only certain types of claims. Claims associated with discrimination, Fair Labor Standard Act cases, and Family and Medical Leave Act cases.
I see that.
Yeah.
So how many people, how many full-time equivalents is going to be doing that?
Well, the hearing officers and the mediators are contractors for us. We're not bringing on somebody full-time for them. But just anecdotally, in having a conversation with the library, they take in about 50 to 60 cases a year, with 5 cases going to an administrative hearing. We currently take in 50 to 60 cases, with 5 cases going to
So
administrative.
you're able to kind of
Well,
budget it a little bit?
Well, we've asked for 2-year money just to expand or contract, so if we need to go into the next year money, we can.
So you're asking for forward funding. Mr. Chair, the last question I have is on ADA inspections. Is that in members' offices as well?
The answer is yes.
I would be interested in seeing that report because I work very hard to have a wheelchair accessibility in my office. There's only parts of my office I can make accessible. Other parts I cannot make accessible at all, no matter what I would choose to do. We could barely have one person walk through an aisle. So I would, Mr. Chair, at some point, if you could provide the committee how out of compliance our offices are with the ADA, I'd appreciate that. And I do mean we're out of compliance. Thank you.
Thank you for that, Ms. McCollum. Chair recognizes Ms. Wasserman Schultz.
Welcome, Ms. Grundmann. When the OOC was created more than 20 years ago now, the idea behind it was to increase transparency, to have the CAA be applicable to Congress as well. So why then has the OOC in practice kept the public in the dark about which lawmakers or officers have been accused of improper workplace behavior?
It's a good question. And the answer is it's actually in the statute. Under the statute, in the statute, counseling sessions, which is the beginning of our process, and mediations, which you have to go through to get to an independent hearing. And I've actually brought a chart if it's helpful to have this kind of conversation. Let me share these with members of the committee. Okay, so let me explain the process, starting from the beginning. Everything starts with counseling, and that's initiated by the employee within 180 days of any given violation.
And this is all statutory?
This is all statutory. It's not regulatory on our part. Counseling under the CAA is strictly confidential, and it not so much binds the employee from speech. It's not a gag order, but it precludes us from publicly speaking about any of these cases. And the employing office is not told at the time that the employees entered the system. So the counseling period can be anywhere from 1 to 30 days. Following counseling, mediation is mandatory. This is when the employing office is brought to the table, meets with our independent mediator, and has a discussion. This is where approximately 40% of our cases settle, so it is a good process. following mediation is the so-called cooling off period. And that's the timeframe that runs 30 days after the end of mediation to 90 days. So their filing window is essentially 60 days. If the employee elects to go to court, they can go to court at that point, litigate in full public view, or the employee can elect to go through our administrative dispute resolution process with a hearing officer and a final decision. The hearing officer is given a certain period of time. I can tell you that our median processing time for these types of cases is 190 days. I do not know what the EEOC's
And
process.
meanwhile, the employee is still working in the office.
That's the problem. Now, the CAA Reform Act that the House passed would address a number of these issues. Counseling and mediation would become voluntary. There'd be a reporting requirement on our part to disclose the stuff. In other words, lifting the veil of the strict confidentiality that you're concerned about.
So that legislation, the lifting of that veil is already in the legislation
Yes.
that we've passed out of the
Yes,
House?
yes.
Okay, but the Senate hasn't taken that up yet.
They're working on it, from what we hear.
So, and the reason that we're not able to implement it is because, on our own, since we've passed it in the House of Representatives, and that's the policy that we have all voted for, is because the statute prohibits it?
Correct.
Or
Correct.
the statute proscribes this process?
Right, right.
There's certainly a need for confidentiality, and I understand that this is in statute, but that confidentiality seems to me to be more applicable at certain points in the process. I mean, the CAA requires an annual report to the public that details initiated proceedings.
Right.
Are you barred by law? Is the OOC barred by law or by internal rules from publicizing annual settlement sums, particularly in a breakdown by office instead of a year-end total? Are you barred from breaking it down that way?
We are not, but here's the concern. The concern is if we disclose by employing office, and some of these, our offices are very small. We're talking about 7, 10 people. It won't be we run the risk of exposing confidentiality of the employee. Now, if there are settlement agreements, let's talk about those in particular. Most settlement agreements, in fact, all that I have seen, contain non-disclosure clauses in them. Those are not by our doing. We don't offer sample language for this for NDAs, and we don't require employees to have them in their settlement agreements. It's a product of the parties' negotiations. But that non-disclosure.
During the mediation?
During the mediation, during the hearing, wherever, any time in the process. If there's a non-disclosure agreement, it means that we can't talk about it.
If they reach a non-disclosure agreement.
Correct.
But before there's a non-disclosure agreement, if there is one, wouldn't it be more transparent to provide settlement information by office rather than to just offer that information in the aggregate?
Yeah, we have,
I mean, we all have about 18 employees. It
Right.
really is unlikely that a specific employee would be exposed unwillingly if you are reporting what office has reached a settlement.
we have provided our oversight committee, CHA, with all the numbers, basically by year. They've also met with us, and they've talked about individual settlements, but we haven't talked about which offices they're attached
But
to.
you aren't prohibited under the law from doing so.
I think we
You're
are
choosing
prohibited.
not to?
No, I think we are prohibited from, under the law, in terms of the strict confidentiality that adheres to each one of our processes and the non-disclosure agreements. We cannot disclose who they are.
Does the law require you to only report in the aggregate, or are you allowed to provide a breakdown publicly by office rather than a year-end total?
We don't think the law allows us to.
When I asked you the question a minute or so ago, you answered differently.
What I'm trying to say is, we don't think the law allows us to break it down individually by office. Now, can we do that? We think we can if the law changes.
But when I just asked you a few minutes ago, you said that you don't offer it that way, but the law doesn't prohibit it because you worry about exposing the employee.
That's true, yes, yes.
So is it prohibited,
We
or is it by choice?
believe it's prohibited.
So then your first answer was not correct?
I misunderstood your question, I'm sorry.
Okay, well, the transparency issue is revolting. It is absolutely unacceptable that we continue to let members who abuse their employees hide. And respectfully, I don't agree with your interpretation of your inability to, instead of report those numbers, those settlement numbers in the aggregate. So I'd like to see the opinion that you've based that on.
Sure.
So, Mr. Chairman, if we could have that information provided by the OOC.
Sure.
Because I'd like to see where that opinion has been proffered to you when it's been inquired about in the past.
Sure.
Thank you. Yield back.
Just so for clarification, is it your testimony then that that has changed under the legislation that's been passed in the House?
The reporting requirements will be, yes, let me answer it. The Reform Act provides for our disclosing members' offices that have had settlements and awards that have come through the Treasury account, that come out of the account. So, and that reporting would be on a 6-month basis to be published on our website,
Office by office,
office by office, particularly with the members.
based on the legislation that passed the House?
Yes.
You think that clarifies the statute or
Absolutely.
directs it, regardless of the question answer you were just having with Ms. Wasserman
Yeah.
Schultz? You think that gives you the direction to be able to do it?
Right.
Does it direct you to do it, or does it permit you to be able to do it?
No, it directs us to do it. We
It
shall.
directs you.
We
Okay.
shall.
Did you have a follow-up, Ms. Wasserman
Yes,
Schultz?
just based on your question.
Sure.
Because my understanding of the legislation we passed was that those settlements would no longer be able to be paid out of a member's office or a committee office, a committee budget, but would have to be paid by the member personally. Is that correct?
So that's a great question, because there is a mechanism that the Reform Act developed. Currently, the way it works is when a settlement agreement comes to us, we request funds from the Treasury to be placed in an account that's designated for payment. After we obtain payment information, the funds are dispersed, and the account is empty. So there is a compromise that the Reform Act struck. Rather than having the employee have a settlement and they're to chase after collecting that fund, the compromise that was struck is that we still pay the settlement or award up front, and we leave it to other means for the member to repay that to the Treasury. We're not in the collections business.
Sorry, what does leaving it to other means mean?
It's in the statute. There is a means for the, they give the member, I believe, 90 days to repay the Treasury. If that doesn't occur, then a garnishment occurs.
That's
And if that doesn't occur, then they go after the annuity.
Okay, that's what I thought it was, but just wanted to confirm. Thank you.
Thank
very
you.
much.
We're blessed this afternoon to have the ranking member of the full committee from New York, our good friend, Ms. Lowy.
So
Chair-
nice that you're blessed.
Well,
We've- We've had
welcome.
several hearings, so I've been running around, but I'm glad that I'm able to contribute a little bit today, and I thank you. I'm sorry I missed your testimony. Following up again, and I apologize if it's repetitive, because I missed so much of that. If the final product is similar to drafts that have been discussed, how long would it take the OOC to implement the new reforms?
That's a great question. The draft gives us 180 days, at least the version that's passed the Senate. We would love a year, because there are a number of processes that need to occur. There's the hiring, the standing up of the investigatory authority granted to the General Counsel. In addition to that, there's the climate survey that we have to contract out for, and that we have to meet with all our committees and all our stakeholders and talk about it and roll that out. And then there's finding more space for the office. In addition, we're going to have to redesign our name. A lot of things are going to change, new rule writing. 180 days is really fast. We would like a year. Now, let me further answer that. What helps us out a little bit in this process is the libraries come under us now. So that gives us an opportunity today to work with the library to develop how they fold into our system. So that's one less thing, in other words, that we have to do.
Now, another question. Should new allegations arise in the meantime, what is the OOC doing to make sure victims aren't misinformed or misrepresented during the transition?
Well, we still have our counseling period, and our counseling...
Still have what?
Our counseling period right here that begins
Oh.
our process. And how that works really is the employee comes in and meets with our counselor, and she explains to the employee what avenues of redress the employee has, such as you can go to the Government Ethics Subcommittee. We understand that the Office of Employee Advocacy is being stood up even as we speak, and for us, it's good, because if Congress is represented but the employee is not, the employee is clearly alone. So this gives us another person to talk to, somebody who also will understand our process, who can explain the ramifications of the decisions the employees make.
Now, in light of the funding the OOC received in the 2018 omnibus, are there additional resources? What would be needed to carry out the new responsibilities?
The new responsibilities, pending passage from the Senate, would essentially increase, actually, we ran the numbers, would increase our 19 request. It wouldn't double it, but it would bring at least another 50% to it, because we would have to bring on investigators to perform that function.
And you've been specific about that and giving that information to the committee?
Well, and again, so when we filed our justification request, the law had not passed. So our budget requests have actually changed over a period of time, chasing proposals, as you will. We know we don't have the investigatory authority currently, so we haven't asked for the investigators because there's nothing to investigate. At the time that we are granted the authority, we are going to be looking for that, either the FTE or the funding for that function.
And I assume you'll keep the committee up to date
Absolutely.
on that request.
That's a promise.
In another area, I know you're aware that the Library of Congress, Dr. Hayden, has an inspiring vision for the library. She's going to leverage their incredible collections, historical artifacts, beautiful architecture, to improve the experience for visitors. And I want to ensure that the library's facilities can safely handle this increased traffic. Can you tell us about any recommendations you have made to the Library of Congress and the architect of the Capitol that might be relevant, and specifically about their stairwell and fire egress needs?
It's a good area to talk about. Currently, our general counsel does all the occupational health and safety inspections, including the tree. He works directly with the parties. We generally don't discuss these items in a public setting. We can arrange a special session with you, with the general counsel, to have a more in-depth conversation.
But you're confident that the plans are progressing appropriately?
They're working with us. The architect is working with us. And these are long-term plans. They don't occur overnight. These are changes, major changes.
Yeah, but a year goes by pretty quickly, and I know there'll be additional requests. It's very exciting, but I just want to be sure that all the appropriate mechanisms are being put in place for review. Yes?
Yes.
Okay, thank you, Mr. Chairman.
Mr. Taylor.
Thank you, Mr. Chairman. Appreciate it. Thank you for being here and all of your work. We appreciate it. A couple quick things. You guys require the General Counsel to inspect all legislative branch facilities for compliance with occupational safety and health standards at least once each Congress. As part of those inspections, you provide recommendations. Do you currently have a list of recommendations that haven't been remediated? If so, how many are on the list? And what happens once you make a recommendation? Is there follow-up on your end?
The process that the General Counsel follows is actually detailed in the report. And it starts with the inspection and then their findings, and if the findings are not corrected, that could result in a citation. Citations can be litigated before our Board of Directors. Very rarely does anything result in a citation, because the goal for the General Counsel is to work with remediation. It's prospective in nature rather than looking backwards at who did what wrong, right? So that is an ongoing process. I think that's a conversation that we could reserve for the General Counsel and make that available, make him available to you.
Okay.
Okay.
Thank you. For fiscal year 19, you're requesting an increase in funds to pay for 3 new online training modules.
Yes.
Can you break down your process for determining when the new training models need to be created, who develops them, determines the content, and how often training programs are then reevaluated to make sure they're up to date with the latest information?
Correct. Well, they must be reevaluated every year, annually, because training becomes stale unless you change it. The current FTE request is actually aimed at development of these modules and updating the modules along with delivering in-person training. Currently, by the end of this fiscal year, we will have 4 online modules that are new. The first one in January was a new anti-sexual harassment, discrimination, and retaliation module, followed by a family and medical leave module that was launched on the anniversary of the FMLA. Coming later on in May is our bystander intervention training, along with unconscious bias. Those are topics, and we've talked about changing the culture in this environment, and changing the behavior is part of it, so that became a top priority for us. Let me also say something about the modules, that the modules are great. They're good for the staff that not in DC, but that's the kind of training that lends itself best to in-person training, where our instructor or educator can engage in a conversation, give and take conversation with individuals in that office. So we are urging in-person training. To add to that, in 19, this is what we're looking to do. Not to forget the other side of our functions, but we are looking at adding an ADA, public accessibility, and common safety and health issues module, interactive, and that will be also for your district offices. I mean, currently our safety inspectors conduct webinars with the state and district offices about these issues, and that's a good thing. It's good for your staff, and it's good for your constituents who come and visit you in your home offices.
Who develops and determines?
We do as a group. We look at priorities. We look at what we haven't covered yet. We look at what the community wants us to discuss. And the community has asked us to focus on sexual harassment and the behaviors that can lead to sexual harassment.
Thank you. Thank you. Thanks, Mr. Chairman.
Ms. Grundmann, how do you store your case files?
I knew you were going to ask that question. So first of all, let me just say that we have not been breached. We have not been hacked. We have never stored our data on an unsecured server. We recognize, and our Oversight Committee has confirmed, that we are Fort Knox, and that's not our words, it's theirs. We are in discussions with our Oversight Committee on how to handle this, but Fort Knox doesn't talk about their cybersecurity or their physical security functions in a public setting. We know you have questions. We want to answer those questions, and we'd be happy to set up a private meeting with you to have that conversation.
So it's your testimony to the committee today that you've not stored complaints on an unsecured server?
Correct.
So the letter from Senator Wyden to your board of directors and the article entitled "Congressional Office Stored Sexual Harassment Complaints on an Unsecured Private Server," those allegations are incorrect.
That's not true, right? Correct.
Those are incorrect
Yes.
allegations. Why do they believe that you have? What do they base that on?
I think this is a better conversation in a private setting.
Okay.
And I'm free after this hearing.
I just think it's a I think concern for the committee regarding how the information is maintained.
No doubt.
And my understanding is starting in FY16, your office began the process of replacing your case handling system.
Oh, it's not a case handling system. It's a case management system. So we can track when cases come in.
Where you
time
store
frames.
them and how you manage them are two different sort of topics here.
They're actually the same.
Okay.
Okay, because the case management system is on this secured server.
So it's my understanding you began the process of replacing the case handling system. Part of the system is intended to have a fully electronic component, which will create a more streamlined process. When will that be in place? And in total, how much will the new system cost?
It is currently in place. What we're talking about for 19 is a new e-filing system.
Okay.
And if you go to the Cadillac series, it's $260,000 for just the initiation, the process itself, and then about $35,000 annually to maintain it.
Okay. Mr. Ryan?
Thanks, Mr. Chairman. So one of the things we think about here on the Appropriations Committee in general, and on this committee in particular, is when we begin doing something, what's it look like today, and then what's it look like 2 years from now, 3 years from now, through the budget cycle, and how much. If we were to ask you to begin the training and in a comprehensive way, like we all feel it needs to happen, Can you give us some perspective on what scaling that up looks like? I know you talked a little bit about some of the full-time employees and what your needs are, but can you give us a little bit more insight on what that looks like?
Well, currently, we have 2 people doing the training who do other functions. We average about 2 to 3 sessions a week. In between sessions, we're spooling up for the next session. We're ready to go now, full blast. Our people enjoy training, and like I said, we have everybody on staff who's trained to do it right now.
Moving forward, there wouldn't be a significant increase in trainers? I mean, we're getting more demand, more people are fortunately coming out, speaking out. That's a good thing. We just want to make sure we're able to handle the demand of that, and at the same time, the preventative part through Phil.
And the focus really is on preventative at this point, the behaviors and the biases. But what we need to do is free up people to do their jobs. I mean, we have safety inspectors and attorneys in our general counsel's office doing the training right now. They need to focus on the case processing as well, the cases and the briefs. We're ready to train now. But we need more staff to be more, to fulfill our other functions as well.
Talk a lot about the video conferencing and the video training, and I think we all know the downside to that. Can you talk to us a little bit about and we know it has limitations, but what are the benefits of that, kind of, that you have seen in your personal experience?
If you're talking about video conferencing, we're talking about video conferencing. Are we looking at your district offices?
Yes.
It's a much smaller setting. It gives employees an opportunity to ask questions of the educator and create different scenarios. It's a much more personalized experience. It can be done. In person is better, but we don't have the funding to travel. It's the second best. It's better than a module. The module is there as the baseline. Then we go to the video conferencing, then we go to in-person.
Gotcha. Thank you. Thanks, Mr. Chairman.
Ms. McCollum.
I want to go back to your alternative dispute resolution. You said 40% of your mediation ends successfully?
40%, yeah.
40%.
Approximately, yeah.
So, I mean, Ms. Wasserman-Schultz was talking, and there was a discussion with Ms. Lowy about members acting inappropriately with their staff. But there's also members' offices where it's staff and staff not acting appropriately with each other. So part of what comes to mind is the length of time, 180 days, and you have an employee maybe who goes through mediation, and maybe somebody decides to leave on their own, they're not happy in the office. Maybe 2 employees actually work something out. But then you have 60% where that's not ending at the mediation. We have interns in our office who can be a summer intern to someone who is maybe going to intern for 6 months, maybe 9 months or something like that. What is the remedy for an employee who is in a work situation, because we've done, and unfortunately some of it's being undone in some of the higher education institutions right now, in dorm room settings where people are living together, because if you're working together in our offices, you're in close quarters. What do we do for someone who comes in as a victim, starting with counseling, moving forward? Does that person, part of the criticism with some of the member settlements where people were removed from the office and paid. We try to get people who are in sexual harassment and sexual abuse systems, women or men, couples, we try to get them separated. Now we have people working together with this timeline. So what is something, if I went in and I was having problems, not with, let's say not with a member, but with a coworker, do you get because you said it's all confidential. If I'm the member, if someone approaches me, maybe I can figure something out.
Right.
To make the work site more comfortable for everybody while this is going through. What do you do?
Well, actually, it's very significant that you brought that up. In some of our training sessions, the member is present, and the member will say, look, I'm telling you right now, if you see any kind of activity like this, I want you to tell me. So, I mean, they're stepping up to the plate. So that's a one-on-one in-person training. Something else let me clarify for you. We talk about 40% of our mediation settling. Not all of them go on to a hearing. There's a steep drop-off from after mediation to an election of a hearing. Okay. So what can you do? Education. You got to train you got to change the behavior. You have to change the climate. And you have to nip it in the bud before it starts. The culture has to change.
I understand that, and I've worked in the private sector, and I've worked on this a lot, and I also serve on the Defense Committee, so believe me, I've been in this over my, over and over again, more, and I'm 63, so I've seen it for a long time. I know what's going on, okay? My question was, if someone chooses not to go to a member, they can choose not to go to their member. Right. They come in, there's something seriously going on in the office. At what point does the member know, or do you contact the member so that the member can make it cease and desist?
The member's office would know. I don't know if the member would know, but the member's office, chief of staff, whomever, would know at the mediation stage. Because in the counseling stage, the employee comes to us, the employee office is not told. If the employee chooses to advance to mediation, then we would contact House Employment Council, and they would represent the member in the mediation session. So presumably, the member would know of any alleged illegal activity at the mediation stage. So that's somewhere between day 2 to day 45.
So to be clear, if and I would hope someone would come to me, but we all live in the real world, right? So someone's in the counseling, your mediator sees something that's pretty alarming.
Mm-hmm.
Your mediator, can that mediator step in and say, wait a minute, we're not doing counseling anymore. We need to move this up.
The mediator's not part of the counseling stage. The counseling stage.
Okay.
Sure.
So are the counselors empowered?
To step in, because of the strict confidentiality clause, no, they cannot tell the employing office.
The press later on. Who's going to be held accountable? We are. And so I get the confidentiality and everything, but if somebody is really under that kind of harassment or duress, that a professional counselor would say, time out, we got to separate these folks, we've got to do something different. You're saying there's no way to step in.
The counseling, and this is going to change, we hope this will change, is a misnomer. The counselor is not the employee's representative. That's why you have the Office of Employee Advocacy coming in. The counselor's only telling the employee what his or her rights are and what avenues they are. It's essentially intake. It's not a therapy process. That's the difference.
Well, I'm not talking about therapy. I'm talking about somebody comes into your office and there's something very seriously wrong going on. Very serious.
Yes.
And it's alarming to that individual. They know it's absolutely wrong. The member's office doesn't find out about it. Can the employee waive that?
Yes.
Do you encourage employees to waive that?
Where the employee would waive it is so if they think that we can make a speedy resolution, a satisfactory resolution, the employee can waive confidentiality, and we would go directly to the employing office.
Mr. Chair, I think this begs to why this system needs to change, and I think the new system, if the Senate ever moves forward on it, we go to it, it's going to have things that have to be worked out as well. This reminds me back in the day when if a police department came upon a domestic violence dispute, how it used to be handled versus how it's handled now. You take care of the victim. Thank you, Mr. Chair.
Mr. Chairman, if I may.
Sure.
I don't want to keep splitting hairs here, but I think it's important. So there's only one blanket elimination of your confidentiality. And maybe one of the things that we need to explore is a limited waiver for the boss.
Mm-hmm.
Because I don't want someone saying, I need someone to intervene here immediately. I'm not talking about a blanket waiver of confidentiality. I'm talking very, very limited, so you can tell my boss that we can fix this problem.
Mm-hmm.
So I don't know.
The employee can do that currently under the system.
And it would be limited. to just the boss?
It wouldn't, it would be limited for the purposes of, to resolve the issue, yes. It's broader than that. It would be to resolve the issue. So the confidentiality goes, the employee's driving it all the way through. He or she's deciding at counseling whether they want to move to the next stage. At mediation, the employee's deciding whether they want to move to the next stage. At the next stage, they're deciding which process to choose. The law, and we understand the frustration. We've been called Byzantine, you know, shrouded in secrecy, but this is the process that Congress designed in 1995, and that's the process you're seeking to change, to lift that veil of confidentiality, and particularly if the employee wants it. Sometimes the employees will come to us, and they don't want us to discuss it with their employing office,
Right.
in which case it ends.
Mr. Chairman.
Ms. Wasserman Schultz.
Thank you. So under the law that we passed, under the bill that we passed out of the House, Mr. Harper's bill, what happens to confidentiality?
Confidentiality is still there. There is a provision for confidentiality. It's no longer called strict confidentiality anymore. We need to reach out to our lawmakers, the CHA in particular, to find out what the change is between strict confidentiality. For us, I don't think anything's changed in the sense that there's no affirmative duty for us, absent waiver by the employee, to discuss their claim with anyone.
So we haven't changed the transparency in the new bill?
The transparency you've changed in terms of our reporting requirements. They're more ample, they're more fluid, and they're certainly more ongoing.
Because I'm looking at the language in the bill, which says protection of personally identifiable information. If a committee to which a claim is referred under paragraph 1 issues a report with respect to the claim, the committee shall ensure that the report does not directly disclose the identity or position of individuals involved in the claim.
You're talking about the Ethics Committee, right? Is that the-
I am talking about whatever this is referring to in the legislation.
It sounds like the Ethics Committee, because we don't have a committee in our process.
The bottom line that I want to know is, have we enabled there to be transparency absent the waiver of confidentiality by the person who is the victim?
We think you have. Certainly, the employee is going to have to choose whether or not they want it disclosed. I mean, there's a competing interest here, isn't there? There's a competing interest for the public to know what's going on. And there's the other interest of whether the employee wants to disclose what's going on.
But what have we required in
In the law.
legislation that has passed the House?
That it remain confidential. That's still there. So is your question that you want to know which lawmakers' offices?
My question is if somebody has abused a subordinate of theirs, whether they are a member or a chief or an LD or anybody, does the law, if this bill became law, still protect that individual if at the conclusion of the process they settle and are found in some way to have been guilty of what they've been accused of?
In the Senate version, the language is extended to naming not just the member, but senior staff.
And in our version?
It is not,
So no one gets named, not in our
just the
version?
member.
So if a chief of staff engages in that conduct, or anyone else that isn't the member, then their conduct is not disclosed.
That's correct.
That is absolutely unacceptable.
Further questions for Ms. Grundmann? Thank you for your testimony today, and we look forward to continuing to work with you on your budget request and these many issues that have been raised today, and we appreciate your work on behalf of taxpayers of the United States.
Great, thanks a
All
lot.
right.
Bye-bye.
This subcommittee meeting is adjourned temporarily, and then we will reconvene in about a minute, in which the Congressional Budget Office will be here to testify.